Hello, and welcome to Supported Decision Making in North Dakota. This presentation is not meant to give legal advice. Each situation is different. Please contact a lawyer if you would like legal advice. Today we will talk about 4 different topics. The first, capacity. The second, what is SDM? Topic 3 is let's talk about it, and topic 4 is do I need it in writing? In 2019, North Dakota put into law what people across the world have been doing since the beginning of time, using trusted people to help with decision making. Today, you will learn more about what supported decision making is, who can use it, and how it can be used. Supported decision making begins talking about decisions. Our first topic is capacity. Who can make decisions? Talking about legal and mental capacity. Starting with legal capacity. Article 6 of the Universal Declaration of Human Rights from the United Nations General Assembly in December 1948 states, everyone has the right to recognition everywhere as a person before the law. This means you have rights and you can do things with those rights legally as your own decision maker. You cannot be your own guardian, and that is because guardianship is a process through the court system where someone is appointed to make decisions for you. So there is a guardian and a ward, 2 people minimum, and you cannot be your own guardian. Mental capacity. Mental capacity is separate from legal capacity. Mental capacity means identifying and choosing something using your values, beliefs, and preferences. It's something we all do all the time. We each make decisions that are best for us based on what we value, what we believe, and what we prefer. What can affect mental capacity? A variety of things, such as disability, age, illness, environment, and other external factors. Thinking about somebody who is sick, and that illness, that period of sickness may create a period where their mental capacity is not what it normally would be. As we age, the same thing can happen. The environment that we're in, stress, and certain situations can certainly affect our mental capacity and cause it to be diminished in certain situations. In addition, disability can affect mental capacity. And it's important to remember, these are often moments in time. Illnesses can often be treated. Medication can resolve things. Reducing stress in an environment or other environmental factors. Disability can involve rehabilitation or adaptations, coping skills, and so it's really important not to treat capacity as a fixed point because it definitely can change. In North Dakota, if a court finds a person lacks mental capacity or is incapacitated, it can order guardianship for that person. The term incapacitated person means any adult person who is impaired by reason of mental illness, mental deficiency, physical illness or disability, or chemical dependency to the extent that that person lacks capacity to make or communicate responsible decisions concerning that person's matters of residence, education, medical treatment, legal affairs, vocation, finance, or other matters, or which incapacity endangers the person's health or safety. And that is from North Dakota Century Code. What is guardianship? Guardianship is a legal relationship in which a court orders the appointment of a guardian to make decisions for another person. The person who is the subject of the guardianship, who is having decisions made for them, is known as the ward. The relationship of guardianship means that someone else can legally make decisions for you, the ward. Guardianship is often referred to as substituted decision-making. Guardianship may be full or limited. Full guardianship means the ward keeps fewer decision-making rights. Limited guardianship means the ward gets to make more decisions independently. Who has what rights is written in the court order and guardianship letters. Guardianships are reviewed every 5 years in North Dakota, so it's important to make sure that you have the most recent court order and guardianship letters so that you can see what rights to make decisions that the ward has and what decision-making rights the guardian has. Even in full guardianships, wards generally have some decision-making rights. An easy way to remember this can be guardianship is a legal finding of lack of mental capacity, which equals a legal loss of legal capacity. The Free Britney movement recently showed the problems many people in conservatorships or guardianships, these definitions and procedures vary by state, have restoring their rights and showing a court that guardianship or conservatorship is no longer necessary due to a restoration of capacity. One way to end a guardianship is to show a court that the ward has full capacity to make decisions. Guardians or substitute decision makers can make decisions for the ward. A guardian can decide for the ward what they believe is best. Supported decision making is based on expressed wishes. This means the individual decision maker decides what they want to do within their legal rights. Dignity of risk refers to the legal right of every person to make choices. People must take risks in order to learn, grow, and have a better quality of life. Someone will never know if they can do something if they don't get a chance to try. We've all failed when we've tried something, and yet we try again. It's human nature to want to protect someone. People who provide care and services for others have duties. They cannot harm the people they work for. This does not mean they have to protect the person from their own choices all the time. It's important not to overprotect the person. Each person has the right to make decisions for themselves within their capacity to do so. Capacity, when it comes to decision making, is not an all or nothing kind of thing. A person may be capable of making some decisions, but not others. They may be capable of making some decisions at some times, but not others. They may be capable of making decisions only if they get help understanding the decision to be made using informed consent. So thinking back to the capacity discussion and what can affect mental capacity, if someone is in a time of illness or great stress, maybe they can make easier decisions, but big decisions might be really difficult. If somebody is struggling with aging and some memory loss, they may be capable of making some decisions at certain times of day and struggle to make those decisions at other times. And some people may just need help getting the information they need to make the decision and understand what they are deciding. Here are your takeaways from topic 1. Mental capacity is your ability to think and make decisions. Legal capacity is your right to make those decisions. Capacity is fluid, it changes. Capacity should be judged on a decision by decision basis. Incapacity to make one decision does not equal incapacity to make others. An individual should never be presumed incapable. Capacity can change over time, and it can be supported. And remembering that capacity is the root of decision making. Topic 2, what is SDM? And you're going to hear SDM used throughout the rest of the presentation, and it stands for supported decision making. Supported decision making, in short, has 3 parts. The first is the named individual, who is referred to as the individual decision maker. The second part is the supporter, to assist the decision maker. And finally, the third part is the agreement. Supported decision making in North Dakota law means assistance from a person of a named individual's choosing. And there's a lot of different things that person can choose to have a supporter help them with. They can help identify, collect, and organize documents and information that may apply to a decision the individual is considering making. They can help the individual understand documents. They can help the individual identify choices available for a responsible decision and the advantages and disadvantages of those choices, including what happens if the person decides to do nothing. They can also help communicate any decision by the individual to other people at the request of the individual. And finally, supporters can go to court and explain the decision-making process allowed by supported decision-making in any court hearing to create or modify a guardianship or conservatorship for the individual. So what this means, an individual seeking support can ask a supporter to gather information, explain information, look at pros and cons, tell other people about decisions they've made, and explain it to the court. In law, the decision maker is referred to as a named individual. This is the person in a supported decision-making agreement who wants help making decisions. The individual decision maker is an architect of the agreement. They choose what kinds of decisions they want help with and decide what that assistance looks like. The individual decision maker can have more than one agreement with different supporters for the same decision or different decisions. So, for example, I could ask a room full of people to help me choose where to eat supper tonight. And I could enter into a supported decision-making agreement with everyone in the room for all aspects of that same decision, helping me choose a place to eat, helping me figure out my budget for the meal, and helping me figure out transportation and how I'm going to get to the place where I'm going to eat. Or I could enter into separate agreements for parts of that decision. I can ask one person to help me figure out where to eat. I can have another person help me figure out my budget. I could have another person help me figure out transportation. And even if I entered into agreements with a bunch of people in the room and they all gave me wonderful advice, as an individual decision maker, I would not have to take the advice of my supporters, and I could walk right down the hall and ask the advice of someone who's not my supporter without entering into an agreement. People with all kinds of communication methods can enter a supported decision-making agreement, whether that's Braille, sign language, using a sight board, or some other kind of method of communicating using sounds or gestures. It doesn't matter as long as they have the capacity to enter into the agreement. How they communicate within that agreement doesn't affect their ability to enter into it. A supporter is a person that has signed a supported decision-making agreement and is agreeing to help the individual. The supporter cannot act as a surrogate or a substitute decision maker. A supporter cannot sign documents for the individual. A supporter only has the authority to do things that the individual has asked them to do. And even if the individual asks them to sign something or make a decision for them, they don't have authority under North Dakota law to do so. The final piece of supported decision-making is the agreement. And in North Dakota law, this means a written, signed, dated, and witnessed understanding or agreement. The agreement is made between a named individual and a trusted adult supporter who agrees to help with the decision-making process. The agreement supports the individual's ability to make knowing, voluntary choices, including choices within healthcare, medical, residential, where they live, finances, their money, education, schooling, legal affairs, and vocation, where you work, and employment. And these areas may look very familiar because they are similar to the areas that would be covered under guardianship in North Dakota. A supported decision-making agreement can't be used to show an individual is incapacitated or incompetent. Just because somebody is asking for help making decisions doesn't mean they don't have the capacity to make those decisions. Supported decision-making law presumes the individual has the capacity to enter into an SDM agreement. And this presumption can only be beaten by clear and convincing evidence. If someone is using supported decision-making, it should be evidence of that individual's capacity. Supported decision-making can be used as an alternative to guardianship. Guardianship laws in North Dakota require the court to look and find whether there is any alternative plan or less restrictive alternative to guardianship to protect the ward's health, safety, or their ability to live independently. Supported decision-making can be an alternative resource plan, and it is a less restrictive alternative to guardianship. There are advantages to using supported decision-making over guardianship. Only a court can change guardianship. Supported decision-making agreements do not go to court. They are made between named individuals and supporters. Supported decision-making agreements are easily changed or ended. Individuals can rely on multiple supporters who have different strengths, expertise, and abilities to help them versus one or maybe two guardians, if there's co-guardians. And so that person, if they know somebody with medical background, that individual may rely on that person to help them make healthcare decisions if that's an area they would like help with, versus having one guardian who may not have that experience. Supported decision-making is a natural fit. Using an individual's natural supports to assist with decision-making can support that person's capacity. This can limit restrictions of an individual's legal capacity as a decision maker. Don't treat a person as unable to make a decision unless you're certain you've taken all practicable steps to help them make that decision, and those steps were not successful. Ask yourself, what have I tried? How did that go? Can I try anything different? Be willing to try again. Supported decision-making is also a natural fit with guardianship. North Dakota law, under general powers and duties of a guardian, already require a guardian to involve the ward as fully as possible in making decisions about that ward's living arrangements, health care, and other aspects of their care. Supported decision-making is a way for that to happen. Your takeaways from the second section are supported decision-making in law has three parts: the individual, the supporter, and the supported decision-making agreement. Supported decision-making can be used as an alternative to guardianship and within guardianship. Supported decision-making can build decision-making capacity, and this can prevent, reduce, or eliminate the need for guardianship. Topic 3, let's talk about it. How do we open the door to SDM? Start by talking and thinking about choices together. This may take time and repeated conversations. Be patient. Questions you can ask are, what kind of choices have you made? What choice do you want to talk about today? Who made the choice? Did you make it by yourself? Did someone help you? If so, who? Did someone else make the choice? Who was that? How did you make the choice? What did you like or not like about making the choice? Can you think of anything that would have helped you make the choice better? Sometimes we think we know the answers to these questions and we figured it out. And we only find out the real story by asking a few more questions and listening. You can use supported decision-making to build capacity. Start small by choosing one decision and practice. Is there anything else the individual decision maker needs to make the decision? Do they want time? If so, how much? Do they want information? What kind? Do they want help telling others about their decision? Does the individual want anyone else to help them make the decision? Even if they have help from one person, they may want help from another person or a handful of people. Identify who that person or people are. Talk with supporters about their roles. Brainstorm. www.supporteddecisionmaking.org has a brainstorming guide, which is a great resource. North Dakota Protection and Advocacy has developed a worksheet to help individual decision makers work through what kinds of decisions they may want to make. Individuals can also choose how they want to make those decisions. Supported decision-making agreements are not intended to be permanent. Trial and error is okay. We all live, we all learn. No decision is too big or too small. Supported decision-making is all about the choice of the individual, and they alone get to choose their supporters. Supporters can choose not to be a supporter when asked, or they can be a supporter but move away in the future or get sick. Keep these things in mind for success when looking at a supported decision-making agreement. Individuals may not have readily identifiable supporters or a robust supporter network. Brainstorm and explore people in the individual's life as potential supporters. Consider people they look up to: family, friends, coworkers, skilled help, neighbors, religious affiliations. If you are a paid service provider, there's nothing in North Dakota law preventing you from being a supporter for someone. However, I would recommend discussing this with your employer prior to entering into any agreement. If you're assisting somebody in identifying potential supporters, ask them, who do you trust? Whose opinions do you want? Who can you say no to? This is a really big one for someone who might be in a guardianship or who has had a substitute decision maker. In a guardianship, the person may have said no to something, for example, maybe a minor medical procedure. And if it was in the person's best interest and the guardian ultimately had decision-making power over healthcare, that guardian may have decided the person was going to have that healthcare procedure. And in reality, that person's no didn't have a lot of value in that situation. So asking somebody who you can say no to is really important to find out. Who listens to them on a regular basis? This is also really important. Sometimes we think we are good listeners and we find out that maybe the person who is talking to us doesn't feel as strongly about our listening skills as we think. Who is easy to talk to? really important questions to dig into who might be a good supporter. There's a worksheet developed by Protection and Advocacy and available on our website that might help a person identify potential supporters. Supporters need help too. Supporters may be people who have or have had substituted decision-making capacity. For example, guardians or people who have informally acted as an individual's guardian, thinking maybe like parents, for the individual decision maker. SDM flips this model on its head. SDM requires the supporter to de-invest themselves in the decisions of the individual. It is a repositioning where the supporter doesn't have that ultimate decision-making capacity, and their job is to find out what the individual needs from them and how they can help. Supporters should be good listeners. They should be able to understand an individual's values and preferences. They should be able to gather and understand information. They should be able to follow directions without judgment and put aside their own values and beliefs. Good supporters should be able to assist even when the decision seems risky or unwise, coming back to that dignity of risk. Even if the decision doesn't seem like a very smart one, it's not the supporter's decision to make, and allowing the individual to make that decision and take some risk allows them to learn from the decision-making process. Finally, good supporters should be able to communicate decisions clearly on behalf of the individual. And remember, supporters can't make decisions. SDM does not give a supporter the ability to act as a surrogate decision maker or sign documents on behalf of an individual. Knowing the individual and their disabilities is fundamental to this process. It's important to understand how the individual communicates best. Is that in written word? Is it in spoken word? Is it visually? Would watching something? Or are they a tactile learner where touching and using their senses means something? What kind of information is most meaningful? Do they need a different format of the information? So maybe a different reading level or plain language or something with pictures and words. What is the individual's understanding of the decision? One great way to check this is to ask, what did we just talk about? Often if you ask, do you understand, you get a head shake and likely agreement. If you ask, what did we just talk about? That person will tell you what they heard and what they understand. And you can decide at that point if maybe some more information might be helpful. Consider using assistive technology. Support is individualized. Support asked for and given will look and should look different for every individual. Decision-making and supported decision-making is voluntary. Remember, the supporter is not deciding anything, and they shouldn't have any skin in the game. Focus on the decision-making process, the how, and not the outcome, the what. For example, someone says, I want to move out. A great response to this is, what I'm hearing is you may want supports to decide where else you'd like to live. This is better than just an okay response of, do you want someone to help you choose another apartment? What happened in that okay response? Do you want someone to help you choose another apartment? That person has bookended the decision to just looking for another apartment to live. Whereas that great response said, what I'm hearing is you may want supports to decide where else you'd like to live. Putting no limits on where that person would like to live, giving them the full decision on where they might want to live. Perhaps an even better response to this I want to move out statement is, tell me more. Why do you want to move out? Because you might find out the person doesn't actually want to move out of their apartment. They may be struggling with something in the environment, like a neighbor who's watching Seinfeld really loud in the evenings and they're having trouble sleeping, or a roommate, some difficulties with a roommate. And so asking those open-ended questions, make sure that your words aren't limiting what kind of decisions are on the table. It's important to define the roles of the SDM participants, the who's, what's, how's, and why's, and whether SDM is being used formally with a signed agreement or informally. What is the role of the individual decision maker? What kind of help are they seeking? What is the role of the supporter? What are they being asked to do? What kind of areas are being supported? What the support looks like, and how the agreement may be ended. The American Bar Association has developed a practical tool to assist lawyers in identifying less restrictive decision-making options. You don't have to be a lawyer to be practical. Use this tool if you're looking at a situation where somebody might need some support or help in making decisions. Takeaways from our third topic: be decision-focused, not goal-oriented. Focus on the decision-making process, not the outcome. Use open-ended questions. Make sure your words aren't in any way limiting what kind of decisions are on the table. It is all about the individual decision maker. It's about what they decide, which areas of support, who is supporting, what kinds of support are wanted, and how that support looks. There is no magic SDM formula. It takes time, effort, patience, and a willingness to keep trying. Our fourth topic is, do I need it in writing? The short answer to that question is no. You can use SDM without a written agreement. However, there are benefits and protections for individual decision makers, supporters, and other people relying on the agreements if they are in writing. An individual may sign authorizations allowing others to share confidential information or documentation with the supporter. The supporter can only get confidential information about the individual with an appropriate written authorization. This authorization can be used to obtain information such as health, education, or financial records. And so this is to support an individual who may be asking their supporter to gather information from them. If we remember, gathering information is one of the things that may occur under supported decision making. And so that individual still has to sign the appropriate authorizations. There needs to be that written evidence that the individual is allowing the supporter to gather that information. There are protections for a supporter. Generally, if the supporter is doing something in good faith, meaning they are doing it honestly and they believe they're doing the right thing, they're not going to be legally responsible or liable for an action unless they are reckless, meaning they're acting without thinking about the consequences. They're grossly negligent. They're acting without using reasonable care, and it's likely to hurt somebody, or they've intentionally done something wrong. People who receive copies of SDM agreements, third parties, also are protected and have some duties under supported decision-making law. They should rely on the supported decision-making agreement unless they have a reason to believe the individual is being abused, neglected, or exploited by the supporter. Or they know or should know the SDM agreement is not valid or has been ended. An example of this might be somebody who put an SDM agreement on file with a medical provider. And either the individual or the supporter called the medical provider's office and said that the supported decision-making agreement is no longer in effect. It's no longer valid. And the person who answered the phone said, sure, absolutely, I'll note that in the computer. And they did, but they never took it out of the file. They should know that that SDM agreement is not valid, and no one in that office should rely on it any longer. Third parties have the same kind of protections as supporters. They're generally protected from legal responsibility as long as they're doing something in good faith and they're relying on the supported decision-making agreement. However, a third person is not protected from being accused of professional wrongdoing and legal responsibility for doing something that goes against the expressed wishes of an individual decision maker. The third party has to follow those expressed wishes. Third parties also need to provide documents, records, or other information to an individual decision maker or a supporter who has written authorization for lawful access to or copies of the information. So if there is that authorization, the third party needs to release confidential information or they could potentially get in trouble. Information that is released as part of supported decision-making is protected. A person or organization who releases that personal or confidential information about an individual to a supporter who has written authorization to receive that information, that third party, the person or the organization, is generally protected from allegations of improper sharing unless they know or should know that the individual has revoked the authorization, meaning that they no longer allow the supporter to gather that information. Or if the person or organization knows or should knows that the SDM agreement is no longer valid. Or if they are knowingly or recklessly giving out information beyond the scope of the authorization. An example of that would be if the authorization allows for 2 months of medical records to be released and the office, for whatever reason, gives out 12 months. They have given beyond the scope of that authorization and could potentially get in trouble for improperly sharing information. It's very important to know what the authorization says and follow it. The supporter then, once they have that confidential information, they can't allow anyone else to access that information. They can't give it to anyone else unless the individual has told them to do so. What are the requirements for SDM agreements in North Dakota? Well, they must be notarized or witnessed. A notary public or 2 qualified witnesses must verify in writing the signatures to an SDM agreement. These are the qualifications to be a witness. A witness must not be a part of the agreement. They must be at least 18 years of age. They must be competent. They cannot be an employee of or an agent of a supporter in the agreement, and they cannot be a creditor, someone the individual owes money to of the individual. There's no required form for SDM agreements in North Dakota law. They just have to be written, witnessed, or notarized. To help you out, North Dakota Protection and Advocacy Project has an SDM agreement template available on our website. SDM agreements are not filed with a court or anyone else, and these agreements are kept by individuals and supporters. So you could take that template and use whatever pages work. Just take the witness page or the notary page. Frankly, it could be written on a napkin, and as long as it's witnessed or notarized, it would be valid under North Dakota law. SDM agreements can be a really big deal for many individual decision makers. They may represent the first time an individual has ever felt the power of choice. That piece of paper can represent their legal independence as a decision maker, and it's a reason to celebrate. Pull out your cameras, take some selfies, eat a slice of cake, hang some balloons. Takeaways from this final section on supported decision making is that it doesn't need to be in writing. Supported decision making can be used with or without a written agreement. Putting the agreement in writing allows you to show it to other people. third parties. And written agreements have protections for the individual supporters and people who rely on the agreement. There is no required format for SDM agreements in North Dakota. However, for the agreement to comply with the law, it must be signed and notarized or signed before two witnesses. Supported decision makings are incredibly flexible for the individual, and that includes how they can be terminated or ended. The individual can notify the supporter by saying our agreement is ended, or any other words that mean that same thing. They can use an assistive technology device to notify the supporter the agreement is ending. They can use any other act showing intent, such as taking the agreement and throwing it into the trash can in front of the supporter or tearing it into tiny bits. They can also put it in writing and give that to the supporter. There can be any other method specified in the SDM agreement. So for example, perhaps the individual only wants support until they have had an upcoming medical procedure or until they finish school. And so you could write that into the agreement. It can be good for so many months or years or days, or it can end on a very specific date. And that would be one way to end the agreement as well. The supporter has only a few options to end the agreement. The first being that they can put it in writing and give it to the individual. The second being if it's written into the agreement that the supporter will only be a supporter for this certain period of time or until this event has taken place. That would be another way. The court can also terminate a supported decision-making agreement. That would happen if the supporter is convicted of a crime involving abuse, neglect, or exploitation. If there was a restraining order issued to protect the individual from the supporter. And in the case that the supporter might lack capacity themselves to make or communicate responsible decisions concerning matters affecting the health or safety of the individual. If you have any questions about supported decision-making, please reach out to Protection and Advocacy through our website or give us a call. We'd be happy to visit with you further about this. Here are some resources that might be helpful if you'd like to look at some more information on supported decision-making in North Dakota and what other countries and states around the world are doing right now. In summary, supported decision-making is a tool which, when used formally or informally, can support an individual's right to be their own decision maker. It is an alternative to guardianship and a tool which can be used within guardianship to build decision-making capacity and support increased limitations on guardianship. Many individuals may be able to restore capacity and end guardianship using supported decision-making. The next few slides contain an example which may be helpful to review to see how supported decision-making might work in real life. Thank you for your interest in learning more about supported decision-making today.